Item number 4 is a motion, Park Kerkorian, relative to the status of the Ellis Act process and relocation of tenants at the Barrington Plaza Apartments located at 11740 Wilshire Boulevard in Council District 11.
And we have a few amendments to offer on this, and I think maybe reading the amendments into the record before we discuss the item would be helpful. I believe you have them, Mr. Brano?
Yes, Madam Chair.
Okay.
We'd like for the item to be amended to include the following additional instructions. Instruct the Housing Department with the assistance of the City Attorney and any other relevant departments as needed to report back within 30 days on all actions the City could potentially take to intervene in the process to ensure that tenants are not permanently displaced. Number 2, instruct the Los Angeles Department of Building and Safety with the assistance of the Housing Department and any other relevant departments as needed to report back within 30 days on the feasibility of establishing a bad actor policy whereby owners are unable to pull permits for new projects if there is a record of unresolved citations, orders to comply, and/or violations at an existing property. And number 3, instruct the Housing Department with the assistance of the Los Angeles Department of Building and Safety and any other relevant departments as needed to report back within 30 days with a comprehensive list of any code violations at the Barrington Plaza Apartments over the last 10 years.
Thank you. And I believe those you're seconding them, Mr.
Yes.
Bloomfield? Okay, great. And we have, I don't know what's happening here. We have the Housing Department and the City Attorney here to answer any questions. And again, I just want to say that this item is not in and of itself an approval or a disapproval of any Ellis Act proceedings. It is a means to greater transparency and accountability on this process. The Ellis Act is a state level process, and I want to invite City Attorney and Housing Department to the table so that we can maybe ask some questions about how that process works and where the city, where the city has a little bit more authority to act, or if not, explain that. We have heard from many people, including some of the commenters today, but we all got emails to our offices saying that the fact that the property owners have been quoted saying that they intend to put these units back on the rental market eventually is a violation of the Ellis Act. And so I wanted to ask about that too, can you explain how this application could have been approved if the owner has stated that they are going to put the units back? Is that actually a violation of the existing Ellis Act and how it's structured, or no? So maybe we could start off with that question.
Good afternoon, council members. Anna Ortega, Housing Department. So this is all based on the city's Ellis provisions in the Rent Stabilization Ordinance, which are based on state law in the state Ellis Act that was adopted in 1985. The city didn't adopt our Ellis provisions until 20 years later in 2005. And our provisions largely mirror state law. And basically, it's a law that says that jurisdictions can't compel property owners to stay in the rental business. So there are a big number of provisions in the city's ordinance that prescribe the process of what the landlord has to file, what rights the tenants have, what happens if the units get put back on the rental market, penalties, if they do put them back within 2 years, what the rents will be if the units are put back on the rental market. So the very provisions in the law anticipate that there could be instances when the units could go back because they prescribe what the landlord has to do if they put the units back on the rental market. It prescribes what the rent's going to be. It prescribes what the landlord has to do to notify the housing department.
2 years, right? Only if it's within 2 years or beyond?
No, there's actually, and this is another area of the city's ordinance where we have, the city council has adopted a number of amendments as we try to close loopholes in this law. So the last set of amendments that the city adopted was in 2017, and the way it's been amended, tenants have the right to return for 10 years. and this mirrors what's in state law. Before that, the city had 5 years. So there's things that are prescribed in the ordinance that talk about what happens if they put them back within 2 years, within 5 years, or within 10 years. We don't approve these applications. We accept them and process them in accordance with all of these local and state laws. We ask what is the intended use, but they don't have to tell us. In this case, they said they were undecided about what the intended use is, but it could be conversion, and it could be to demolish. There's a number of uses that landlords can do to use the Ellis Act. It can also change their minds. Sometimes funding falls through, approvals don't happen, so the ordinance itself allows for what the provisions are if the units get put back on the rental market. Anyway, for this one, they filed on May 18th, so almost a month ago. They filed on May 18th. Tenants have the right to claim an extended tenancy. All tenants get a minimum of 120 days, so that would be through September 8th to relocate, but elderly and disabled tenants can request an extension to stay up to a year, and they have 60 days to claim that, so those have to be in by July 7th. On September 5th, the 120 days will expire, and unless the tenant's got an extension, that's the move-out date. The 1 year for the elderly and disabled tenants would be May 8th, 2024. So we're early in the process. The provisions require relocation assistance services to the tenants that the landlord pays for, but that is facilitated by our department. So we have a contractor that's assisting the tenants. They're called InterWest. They help to determine what's the correct level of relocation assistance, which depends on the tenant household composition. So it ranges from $9,200 to $22,950 per household. So all of that is underway right now, where tenants are possibly requesting their extended tenancy. The relocation service provider is assessing the level of relocation assistance for the tenants, and information is going or has gone out to the tenants.
And, I think I find the prospect of this, as some of the commenters said, I think it's horrifying to think during this housing crisis that, hundreds of residents could lose their homes in one of our city's neighborhoods right now through a process that feels like it has pretty major loopholes. Wanted to ask, I know we're asking for a report in the amended motion, but if you could speak to what tools a city may have to prevent the permanent displacement of residents, and I invite any of you to answer. If you can answer now, or if you'd prefer to answer later, that's fine, but I'm really curious to understand more.
So we don't approve these applications. We process them in accordance with state law. So we ensure that they file the right forms, sign everything, provide the required notifications to the tenants, that the timeline is followed, that the tenants get the information on their relocation, things like that. But this is a ministerial process for the city. We don't get to second guess the landlord's right to remove the units from the rental housing market. We can report back, in consultation with the city attorney about any special circumstances involved in this case.
Okay, are there additional questions from the committee? Go ahead, Mr. Bloomfield.
Thank you. Are these, as I understand, that some of the tenants are filing a declaratory relief action to find that this is an improper use of the Ellis Act. Is this something that the city can intervene in that lawsuit?
I think that's a question for the city attorney.
Yeah, I think so too. I'll put it out there, but to get an answer back as part of our
I think
back?
it might be part of our report back, which might need to be in closed session.
Okay. Well, I'm formally asking for that to be part of the report back, as one of the things. And the owners of the building claim that they have to evict all the tenants to do the repairs, but the construction experts say that the work can be done in stages. Is that true, and can the permits be modified to require this to minimize the disruption?
We don't second guess the property owner's determination on how to stage the work that needs to be done. I do understand that it's, because of the way the buildings are constructed, that the work is extensive. Possibly it could be done in stages, but we can't really dictate how they do it. It's not at the stage of pulling a permit necessarily. Right now, they're going through the Ellis process in order to eventually vacate the building to do some work. We have not approved permits, and I think we would need industry experts about the kind of work that's needed to be done to say whether it could be done in stages. It's my understanding that the construction type of the buildings and the type of work that they need to do makes it very intense construction work that's needed throughout all of the floors. So it's not an easy project.
I'm not saying it is, just saying, we're looking for any sort of leverage that we have to protect the tenants, and if there was a way that we could stage those permits, if that was legal for us to do, then that might be something worth exploring.
It might be. I think that might be a building and safety question.
Okay, I don't throwing them out there for us, but you're the ones in front of us. So, and then, has a tenant habitability plan been submitted for the building to enable temporary relocation rather than eviction?
No, but tenant habitability plan isn't triggered right now because that gets triggered when they pull the permits. And it only applies to buildings that are occupied, but the way this would proceed, the building would be vacant. So that would not trigger a tenant habitability plan.
Yeah, it seems like that they're intentionally doing it to avoid that.
And they did have one filed, right? They had violations that led to pretty big fires, and LAHD did ask them to create a tenant habitability plan and to make these repairs at that time, if I'm not mistaken.
There's been no tenant habitability plan. They had to pull some, I think it was a permit from building and safety for the area with the fire, but by that time those units were vacant, so there was no THP required for that.
And when the fires were happening, was there an effort made to say you need to make these improvements and here's the plan how you can make these improvements for the building? Because there have been 2 fires there, right?
Over the several different years, there were at least 2 serious fires.
And so what was LAHD's response in those cases?
Those orders were written by building and safety.
Mr. Alman, I believe that there was an attempt to do that. The council member at the time was not cooperative.
I couldn't hear you.
There was an attempt, and I think there was a plan, if I remember correctly, submitted to try to do it floor by floor, to try to address some of the different needs, but they had an unwilling council member.
And when was that?
2 years ago?
Yeah, 2 years ago.
2 years ago, the council member at that time obstructed that opportunity, so,
After each fire, we always brought something forth.
that's right.
You're saying what was brought forth was a tenant habitability?
It was brought to the council? Can you speak to that question?
I'm sorry, I didn't catch the question.
Councilmember Lee's mic is not working, I believe, but I was just asking what happened after the previous 2 fires. What was the engagement from the city to create a process that could create a safer environment for the residents and still keep the residents there?
I'm going to ask our Director of Code Enforcement to assist me in answering that question.
Okay. sorry, I don't have this background.
Good afternoon, committee members. Robert Gallardi, Director of Code Enforcement, Housing Department. Regarding the
Well, we can't
permit
at all.
requirements, after the fires occurred at Barrington Plaza, the property owner applied for permits to make repairs to the building. The requirements set forth, dependent on those repairs, would have and are the responsibility of the Department of Building and Safety to administer and apply to the building, not housing.
Okay.
I'm sorry, I don't quite follow what you're saying. So it's building and safety that would make those requirements?
So, correct. So when the owners of Barrington Plaza, their contractor applies for permits to make the repairs subsequent to a fire, the requirements set forth for those repairs based on the time of those fires would be administered through the Department of Building and Safety's interpretation of the code requirements to make those repairs.
Okay. And then that happened after the fires?
Right.
So, yes, there was 2 fires. There was one in, I believe, 2014 and again in 2019.
And then was there a tenant habitability plan put forward?
So I believe not for either the 2014 or moving forward for the 2019 fire, because those areas that were affected by the fire had subsequently become vacant areas of the building, and the tenant habitability plan is set in place to protect occupied dwelling units, not vacant.
And have they since been occupied?
No, they're vacant.
The 2014 fire for sure. The 2018, I don't believe so. Excuse me, the 2019 fire.
Right.
I think what might be helpful is in, as a part of the response to item, the third part of the amendment would be to just provide what happened after the previous code violations and the fires, which might shed more light on this in greater clarity and would include, we've included the DBS in there as as an entity to report back, so they may be able to provide greater clarity on what happened.
As a matter of fact, right now, there are 712 units there, of which 577 are occupied.
Got it.
So it's my understanding that the units that were affected by the fire remain vacant, by the 2020 fire.
Okay. But the previous fire,
Right.
folks have been put back in, so there could have been a plan put in place for the previous folks.
Got it.
The folks who've been,
This could have been avoided.
It's gonna what?
Potentially could have been avoided, I guess.
It could.
Okay.
And then just, I'm sorry, go ahead.
I'm sorry, council member. It's hard to hear. Could you repeat the question?
Oh, that wasn't a question. We was just trying to figure out what happened in all this.
Yes.
Which I think we're piecing together. And I know other folks have questions. Just one broad question, though, which is not so much building safety question, but a bad faith Ellis Act. What would be defined as bad faith Ellis? Is that a legal thing? If someone is intentionally not getting out of the rental business, but saying that they are, do we have any leverage over that? Or can any property owner anywhere in the city use the Ellis Act to evict folks with no intention of getting out of the rental business? Because I always thought it meant you have to be getting out of the rental business or have that intention.
And I think a lot of the commenters also thought that.
But-
that.
The property owner doesn't need to tell us why they want to get out of the rental business. I mean, we believe that they're filing with a good faith reason to want to withdraw from the rental housing market. But again, the Ellis Act itself provides for what happens if the units for some reason are put back on the rental market.
But if there is a bad faith, I mean, is there any provision for bad faith? I mean, if it can be shown that they really don't intend to get out of the rental business, that there is clear and convincing evidence that they are intending on remaining in the rental business, that we would have some way to use the Ellis Act to prevent them from doing so.
There isn't a provision in the ordinance that allows the city to disallow the filing of an Ellis application, or of an Ellis filing. It's not even an application. So I think this is a situation we have not encountered before. I think it might be a question we could examine further with the assistance of the city attorney. But it's the way the law is, the city can't interfere with the landlord's unfettered right to exit from the rental housing market.
Right.
And the provisions in the law talk about the tenant's right to return if the units are put back, the civil penalties, the landlord's obligation to inform the housing department that they're putting them back. So it does anticipate that there could be situations when units are put back on the rental market.
Okay, well, and part of the amendments for this is, in addition to all of the great things that Councilwoman Park put in, we just added some amendments to get back what are our legal options as part of the report back, so.
Okay, so if we have no other questions, I think we can vote on this item as amended, and look forward to getting a report in a timely fashion, as well as greater transparency on what process is happening. Could you call the roll, please?
Councilmember Rahman.
Yes.
Councilmember Blumenfield.
Aye?
Councilmember Harris Dawson.
Yes.
Councilmember Rodriguez.
Aye.
Councilmember Lee.
Aye.
5 ayes, and this item is approved as amended.
Okay, thank you very much.